Get ready. 3 seconds. 2 seconds. Start. This intra-court appeals impugns the order dated 15/10/2012 of the learned single judge of dismissal of WPC number 655/2012 preferred by the appellants. Full stop. The said writ petition was preferred challenging the order dated 30/8/2012 of the Central Information Commission dismissing the second appeal preferred by the appellants against the order dated 21/5/2011 of the first appellate authority. Full stop. The first appellate authority has dismissed the appeal preferred by the appellants against the information dated 18/3/2011 provided by the Public Information Officer of the respondent bank in response to the application dated 19/2/2011 of the appellants under the provisions of the Right to Information Act 2005. Full stop. Para. The first appellate authority in its order dated 21/5/2011 held that though information sought by the appellants had been provided to the appellants, the grievance of the appellants was that the information supplied was misleading and wrong. Full stop. The first appellate authority held that information in possession of the respondent bank had already been provided and no opinion as sought in the application could be provided. Full stop. The first appellate authority also did not find any discrepancy in the information provided. Full stop. Para. The CIC in its order noted that the appellant number 2 had been removed from the service of the respondent bank, that the appellants had sought information on 39 points, that the appellants had filed 50 to 60 RTI applications in their names, separately, together, as well as in the names of their friends and also through some advocates, on the same subject and on the same questions, that the appellants are misusing the RTI Act needlessly. Full stop. The CIC further, on examination of the record, did not find any reason to interfere with the decision of the PIO and the first appellate authority of the respondent bank. Full stop. Before the learned single judge also, the contention of the appellants was that the information given is not correct. Full stop. The learned single judge went through the RTI application of the appellants and the response thereto and found that the information sought had already been furnished. Full stop. The learned single judge has further observed that the only obligation of the respondent bank from which information had been sought under the RTI Act was to give information available and no further, and the said obligation had been fulfilled. Full stop. Para. The counsel for the appellants does not controvert the factum of a number of RTI applications having been filed by the appellants themselves or through their person to the PIO of the respondent bank. Full stop. He has, however, drawn attention to the information sought at serial number 11 to 14 and 26 of the RTI application and the response thereto, and on the basis thereof has contended that information has not been provided and the information provided is incorrect. Full stop. Para. The proceedings under the RTI Act do not entail detailed adjudication of the said aspects. Full stop. The dispute relating to dismissal of the appellant number 2 from the employment of the respondent bank is admittedly pending consideration before the appropriate fora. Full stop. The sub-purport of the RTI Act is to enable the appellants to effectively pursue the said dispute. Full stop. The question, as to what inference, if any, is to be drawn from the response of the PIO of the respondent bank to the RTI application of the appellants is to be drawn in the said proceedings, and as aforesaid, the proceedings under the RTI Act cannot be converted into proceedings for adjudication of disputes as to the correctness of the information furnished